Good night, Tobago. And we are live in Tobago Update Studio once again with For the Hour. My name is Edison Thomas and I will be guiding tonight's discussion. I hope that you have been having a great Monday so far, all right, in so much as you have set up yourself well for the rest of the week. We always say Monday is the best day to set up a good tone to have a productive rest of your week. All right. Today I had a little bit of spare time. I went to the beach, took in some sun, some rays, walk in the sun a little bit and enjoy the beautiful, serene. The water is wonderful right now. All right. Serene surroundings of Tobago, just to clear your mind and get yourself right for the rest of the week, right? It was indeed wonderful. However, this can't necessarily be the case for everybody. I mean, I had time today. It doesn't necessarily happen every day, but I had time today. But for the rest of Tobagonians, Monday is usually a work day. And segue into what we want to talk about tonight in terms of Tobagonians being productive, Tobagonians and their working situation. And by that we mean labor. All right. So tonight our topic is we're talking about labor. Some of the issues that we come across in Tobago. And we're speaking with Tobago and Trinidad on a wider sense because what they do down there would have implications for how we operate up here. All right, and we're dealing with some of the issues that arise that tend to be, common issues that we see, right, in the Tobago space and how we are to deal with it, right, and just educating Tobagonians on their rights as workers, right, because you do have rights as a worker. All right, to protect you from becoming exploited by whether it be the public sector or the private sector. We would love that everybody knows their role and function and exercises their role and function, and everybody knows their rights. But we all have competing interests. And so my thing is that you, as a worker, have a responsibility, right? When you're working in any company, the THA or any private enterprise, to know your rights so that when the situation arises, not if, it's when the situation arises, you'll be aptly informed to know how to traverse, all right, instead of you being lost and you being taken advantage of. All right, so to talk about our topic for tonight when we're talking about labor, right, we have joining us in studio is Mr. Max James. And we have to outline the expertise of Mr. Max James so we know that he is aptly qualified to talk about this topic, right? So Mr. Max James is the former Labor Secretary of the Tobago House of Assembly. He's also an industrial relations consultant at present. He's a former member of the Public Services Association. He's an advocate at the Industrial Court, Trinidad and Tobago. He has an MBA in Human Resources Management, and he has his national diploma in labor studies. All right, so good night, Mr. Max James.
Good evening,
how are you doing?
Thanks for the kind introduction.
No problem, Mr. James. And of course, no stranger to the show. Obviously, in other, when we talk about other topics, we lean on your expertise as a former politician and member of the administration in the past. All right, and also joining us on virtually, all right, is Mr. Clyde Weatherhead, who is a former president of the Public Services Association. He's a prominent attorney at law as well, and he's also an advocate at the Industrial Court. All right, so good night, Mr. Weatherhead. How are you doing? How Trinidad is right now?
Hi, good night. Well, Trinidad is a little quiet today. Traffic a little less than usual. But other than that, same problems.
Right.
Crime and other difficulties.
Right. All right. So there are three topics we really want to touch on tonight, mainly. If we have time, we'll go to others, but three topics we want to touch on tonight. One would be the issue of fixed term contracts. We also want to talk about workers' rights and disciplinary action. All right. Three very important topics when it comes to any in industrial relations, right? These three topics are constantly argued, right? I would say when you see workers' rights being trampled, you usually see disciplinary action being taken wrongly and all of these different things. But those are the main topics that we're going to talk about tonight. So we're going to start off with the fixed term contracts.
Those guys fixed on the screen. Fixed term.
Fixed term contracts, all right? So I wanted to ask this question, right? We have in the national space, all right, we've seen a lot of companies within the last, let me say within the last 5 to 7 years, whether it be state-owned or privately owned, they would have more or less done some restructuring or retrenchment and laying off of workers. All right. I bring specific reference to TSTT recently. We had ArcelorMittal, we had Petrochin, right? And recently in Tobago, I think CPEP and TATCO. All right. Now, what I observe in the national space when it comes to restructuring of companies and winding up of people contracts and so forth is different to how I see it happening when it's practiced in Tobago, right? And so I wanted to clear up some of the misunderstandings when it comes to the administration of fixed-term contracts locally in Tobago. Because in Trinidad, we see that when TSTT wrapped up person's contract and sent them home, in terms of retrenchment, they would have paid a lot of money in retrenchment benefits. We saw the same with Petrotrin. The government actually boasted that they spent over $1 billion in retrenchment benefits for Petrotrin workers when they were sent home, right? As well as ArcelorMittal, I believe that they would have had some kind of settlement as well. But when we see it practiced in Tobago, we're seeing instances, and too many, of workers just being sent home with nothing, not even a thank you. So I wanted to address that. So we start with you, Mr. Max James, and what your view on the administration of fixed-term contracts in Tobago. What are we doing wrong? Is it that is it that they're doing it right in Trinidad, or they're doing it right in Tobago? What is that is the issue there?
Okay, well, thank you, Mr. Moderator. But I think it would be good for the listenership to give us sort of a historical perspective on the development of fixed-term contracts. And I had the good fortune as when I was the Labor Secretary in the Assembly to go to Switzerland at the International Labour Organization conference. And that was somewhere in, I think it was 1998, thereabout, 1997, I can't remember which year. However, the world began to look at fixed-term contracts as the way to reduce the whole question of pensions, public pensions and so on, and those kinds of benefits, as a way of control the fear factor, rather than relying on the human resource management and principles and concepts and construct of an organization. And I'm sure my colleague, former president, will develop more on that. But the world started around that time, just before that time, to go the way of fixed-term contracts, so that reducing the size of the public service, because politicians believe that they should have more control over the workforce, which is really none of their business. And I say that because people be shocked at me saying that. But there is a gap between the public officer and public policy which they're going to carry out, and the politician makes the public policy.
Right.
But in terms of the disciplinary aspect, in terms of the direct control aspect, it is for the public officer. And we have in our jurisprudence, in our area of authority here, we have the CPO, and we have the Director of Personnel Administration. And of course, you have boards of directors, and you have chief executive officers. But we see an invasion of that public servant or public service space by the politician. Now, I recall in the days of Eric Williams, when he was the politician, in the days when I suspect fairness and advancement of the society, those things were occurring. Even Williams himself said, listen, he understood the plight of workers. He understood that he had to protect workers. He had to give them rights and to protect their rights. But what you see today is an emerging and very frightening situation where the public service space is being intruded upon and not allowed to function as it was designed to function by the founding fathers. Right. And I say the founding fathers of labor, trade unionism, and the founding fathers immediately post-independence. Right.
So you're talking about Mr. Butler and
those guys,
yeah.
Butler, George Weeks, Cyril McLeod, even my friend here, Clyde Wetherhead, we work together at the PSA. And it's very disturbing, and to me, when I see workers' rights being eroded upon, and then you have people who don't know the law, they employ all sorts of fancy lawyers to look at loopholes to get away, and then they say, well, we will take these actions against workers, and we will pay later down if we're going to pay at all.
Yeah.
But there is something called a penal code, that when the court makes a judgment, they better follow the judgment, because a term of imprisonment can be instituted against any politician or any organization refusing to carry out the judgment of the court, whether it's the High Court or the Industrial Court. So that we have seen on the national stage where, in terms of those organizations you have referenced, the right thing being done in terms of process. In for example, WASA went through 2 sets of restructuring. You have TSCT itself went through 2.
TSCT, yeah.
But there's something that is called the overriding public interest. There's something called a cabinet minute. There's something called a board minute. There's something called in human resource management that is called organizational development. And therefore, within that process, there's something called an organizational diagnosis. So you have to have the diagnosis. And then you have to, if you wish to restructure, then it must be done properly. It must have the overarching cabinet minute or board minute and instruction and authority to do so.
And it must follow the law.
And you must follow the law. And there's a process, because the court is big on process. So if you let go people and you can't establish to the court the reason why you are taking this particular action, whether there is a problem with finance, or you just have to...
Or redundancy. Yeah.
Well, yeah, I know. And the court will ask, if it is challenged, was it really truly under these positions were redundant? Particularly if the organization is an ongoing concern.
Right.
Like in the case in TADCO. So you hire new people, and you fire other people, and we will say it's a dismissal, because we know it's a dismissal. And the court will say, how could you do such a thing? Because it's an ongoing concern. You can't dismiss people and then rehire people in ostensibly, and I use that word, ostensibly the same position, the same function.
Right.
So that there are organizations that follow the process, and there are some that don't. Those that do, you find those are the non-unionized organizations. And it's appalling today where, even here in Tobago, people are afraid to even come on a program. They're afraid to march. They're afraid to stand up for their rights, because they believe, because the Assembly is the largest employer, and they're afraid to see anything. And we just cannot function in such an environment. We must not.
You can't have proper productivity on that kind of...
Those who are empowered today must ensure that the workers must not be afraid.
Right.
I remember the Chief Secretary saying in his electioneering campaign that an employee should not have to fight for something that he or she is entitled to. And it was a concept I learned many years in my junior years, where the way how industrial relations should be prosecuted and managed, no employee should have to fight for something that they're entitled to.
Right.
So I'm hoping that persons who are listening tonight, whether you're a TPP or PDP or UNC or whatever, it has nothing to do with me. I'm only trying to help those who are helpless. Maybe I was born for this time.
For that.
Because the people who are involved, and Klein and I were discussing it a few weeks ago, you don't have active trade unionists anymore. The trade unions of the ilk of Clyde and myself, where we would march and hold a flag for a serious cause, it is diminishing or perhaps dead.
Right.
The people who knew and understand, we who fought for the rights of workers and made them into law, it's a dying breed.
Right.
And I cannot stomach whatsoever, I will not tolerate whatsoever any worker's right being trampled upon or taken away whilst I have breath. Right. It doesn't matter whether you are my relative or my leader or whatever. I would respect you and follow you only if you will obey the law.
Yeah.
And obey the law and obey the law, because that's what you're sworn to do.
Right. Well, let Mr. Clyde come in. Mr. Weatherhead, fixed term contracts and the administrations of such and the state of how the country is right now. We want to get your opinions on that before I ask some questions that I have in my mind.
Sure. Let me deal with this issue of fixed term contract itself. There are many cases in the industrial court, some involving the THA, in which the issue of fixed term contracts have come up. And the court's position basically is we have to look in each case to see whether, in fact, it is really a fixed term contract. And some of the factors you have to look at is the function being performed by the worker under this contract a permanent function within the organization. So therefore, is the fixed term contract really a guise to try and prevent the workers from having permanent status within the organization? Now, in the public service setting, public service employment was recognized in a case some years ago by then Justice Smith. He's now an appeal justice. And in that case, he said, using an Irish case that was presented to the court, McClellan, that public service employment is a particular category of employment that is permanent and pensionable. Now, since the NAR days, since the 80s, what has happened in the public service, including within the THA, is that the different administrations have been using contract employment to move away from permanent pensionable employment in the public service. Now, that has a significant kind of situation, because once you put somebody on contract, they are no longer a public officer, because within the Constitution, between that and the Civil Service Act, for example, or any other service act, a public officer is someone holding a public office, and he's appointed by a service commission. So if you are on contract, which is done by the PS or the chief administrator in Tobago and so on, you are not appointed by a service commission. You are not in permanent and pensionable employment. So you are not a public officer. You are a worker within the meaning of the Industrial Relations Act. And that has several important implications. Public officers, if they are to be promoted, transferred, disciplined, terminated, that is to be done by a service commission. If they are contract employees within government employee, including in the THA, then you are a worker and you are not to be disciplined by a commission, but by various administrators at different levels of the organization. And your remedy, like public officers go for judicial review in the High Court, for example, if they are wronged by a commission or by a PS who has delegated authority from a commission. A worker goes to the industrial court. So, for example, the PSA has recognition in the public service that is written into the Civil Service Act. But the people who in the public service area, whether in the THA, in the judiciary, or in any ministry, if they are on contract, they are not public officers, they are workers, and their remedies would lie in the trade disputes process, which includes the Minister of Labor and the Industrial Court. It is not the question of the High Court and judicial review, etc. So there's different things. The PSA, for example, is not recognized to represent contract employees in the public service. And if you look at the industrial court, a lot of people coming out of the public service, and again, including THA employees, who have gone to the industrial court, have been represented most times by unions other than the PSC. Many of them have been represented by BIGW or CWU or some other union, because where they have individual matters, those matters are heard by the industrial court because they are workers within the meaning of the law.
Right.
Now, you mentioned something earlier. I just wanted to clear it up. You said that TSTT paid retrenchment benefits. And if you listen to the workers at TSTT recently, they have not all been paid, and they have not been paid all of their retrenchment benefits because the company said, we don't have money, we're going to stagger this thing over years. In the case of ArcelorMittal, because that is a private company falling under company law, the retrenchment benefits would have fallen under a charge on the company's assets. And there are different creditors. The workers would be creditors owed those retrenchment benefits. And there are other creditors who have priority. For example, the banks, if they have debentures or loans or mortgages and so on. So by the time you get around to the workers, there's nothing left. And that is a real failure under the Retrenchment and Severance Benefits Act combined with the Company Act, because what that means is that the workers in where a company closes down, in the circumstances of ArcelorMittal, where they completely close down, the workers probably will not get a cent. And that is the difficulty.
All right.
So
all right.
we have fixed term contracts, like I say. The court has said on many occasions, again, including some THA cases and Airports Authority and so on, that you have to examine in each case whether it is truly a fixed term contract. If the function continues and persists, then you may be using a ruse to tell the worker, listen, you're only here for three years or 1 year, and these days in the public service, they are using 6 month and 3 month contracts in which people have no leave, no sick leave or anything like that, which is, as far as I'm concerned, illegal.
It was always my impression that these fixed term contracts were to be used in situations where you have projects that have hard scopes. So for instance, there is an accounting job that the project's supposed to be 3 years long. They might be doing auditing, or a construction job where you need a project manager, and that project manager, that project's supposed to last about 4 or 5 years. And so you want to have somebody employed for that specific period of time because the project has a hard end. All right. And so even in my young days, I saw that companies would have been using the existence of fixed term contract to tie them to functions that, I mean, you don't have a hard end on the duty in your company, but you're using a fixed term contract for the employee for that has a hard end, and for me that it doesn't make any sense. But I have some questions here that I needed to line up, because we have a number of things even within the fixed term contracts. There are some clauses and stuff like that they put in them that makes it even more difficult for the worker. All right, that gives the employer even more power and opportunity for abuse. Right. So one of the things that they put in contracts these days, fixed term contracts, is probation. All right, and in probation terms, when you're under probation, you're looking at, well, for me, the reason why you're under probation is because they want to look at your performance and stuff in a little bit more under the microscope to see that if you're a proper fit for the company. What we sometimes see within contracts, that probationary period is up and they just let you go. And there was no reason, other even performance related, is like, okay, it just means that you could fire at any time. That's the MO, when we could let you go at any time for the probation, right? But I want to know if it is that is right. A worker coming
Actually,
under a
that
contract.
Sorry? That's a mistaken bit of thinking on the part of employers. During the 1990s, there was a worker on probation at Princess Elizabeth Center, and she was terminated. And I did that case in the industrial court, and the court basically said her termination was harsh and oppressive and contrary to good industrial relations practice. Somebody being on probation, the industrial relations jurisprudence in this country has always been that you are to be having sympathetic supervision. In other words, probation is not something to see if we could fire you. It is to help you to best fit into the company's operation, so that if somebody is on probation, you cannot simply terminate them. There has to be a reason, and there has to be an opportunity for the person to defend themselves.
Improve, I would guess.
Yeah.
We'll go to Max. Go ahead, Max.
Well, I could go as far as the Privy Council on that matter of probation.
Mm-hmm.
I don't have the specific case on my list here. However, Lord Denning would have instructed us in that regard, and he's clear that you can't contract me for 3 years and insert a clause, a probationary clause that determines that I could be dismissed or let go, whichever way, at any time between 1 month and 3 months. So I would say it's an egregious clause that they actually insert there, which is really not a question of law, but it's really a question of human resource management. It's a management issue and not, in one sense, a legal issue, because you're talking about human resource development. You're talking about performance management. And unfortunately, there are some of us today who eschew the whole question or disregard the whole question of performance management. That is what we went to university to study.
Right.
And that is what organizations function on the management of human beings and how they function in an institution, the purpose for which an organization was established, and to meet its goals and objectives. So you need people. The objective is not to fire people. The objective is to develop people towards your objective, towards your goals. That's the purpose of human resource management, achieving the company's goals. And the courts will tell us that dismissal is the last
resort.
Now, I just want to turn our attention to one of the cases. I think you might have it there. But this is a case, Clyde, and this is a case, perhaps you might put it on the screen for everybody to see. Because I don't want it to be my words, but I want it to be the court's words. And I'm hoping all contract workers, all employers, whether public or private, must understand what the case says. It says here, in the first place, for every public officer and every contract officer, various authorities have to view that a reasonable expectation renewal can exist, even though the written contract of employment expressly stipulates that the employee fully understands that he has no expectation of the contract being renewed. The Supreme Court, I will forget the citation, although the terms of the contract in this case were clear and explicit and left no room for the entertainment of renewal, the court held that assurances given to the workers outside the agreement clearly conveyed to them that they could entertain such expectations. The employer basically overruled his own agreement. But let's come to the juicy part. Can an employer create a legitimate expectation of permanent employment upon the expiry of a fixed term probation? And the court is saying, yes, the court found in the affirmative. The problem the employer faces with fixed term probation is that it creates the impression that the employee will be permanently appointed if the employee performs sufficiently during the probation period. So it's a human resource issue. If the employer did not address poor performance during this period, whatever the probation period is, it will have great difficulty in arguing the substantive fair reason for the non-renewal. The court is saying, once you employ me, it's a going concern. It's a more or less a permanent concern. Unless you have an overriding public interest, unless you're going to involve yourself in some kind of restructuring or retrenchment, and the court will determine whether you did that correctly in the first place, then I have a legitimate expectation for a renewal of my contract, even if you told me that don't expect a renewal. The court is saying, no, that process is wrong. You have to re-employ me on contract along the same terms or superior terms to the last one, but not inferior terms, and so that I can function. What you find employers doing these days is to disregard the ruling of the court. So unions and people like myself are going for exemplary damages. Right? Because you have it in front of you. You allow people who don't know, or you allow some smart lawyer to tell you, let's carry them to the court. They have a good case. Let's delay it. And you have examples where employers have been paying millions of dollars. And I dare say, and I put this assembly on notice, whether they want to believe it or not, or allow their lawyers to fool them or to take money from, that's what their lawyers are going to do, some of them.
They'll enjoy it out, take money.
If you multiply, let's say in the case of TATCO, the 65 or 70 workers, thereabout, and even if they take back some of them, you're likely to have close to about $30 million in the next 2 years to be paid out of assembly funds. So they could jump and laugh, and the board and their people could jump and laugh as much as they want, or disregard the rule of law. And they feel that they're doing well, and they talk amongst themselves and believe they're doing well. But you cannot and must not disenfranchise workers. We'll deal with the social fallout in a while, but I'm sure, let me listen to Clyde, what Clyde has to say on it. But the law is very clear on the renewal of contracts. You must be renewed if you did not address poor performance. So if I didn't perform poorly or badly, or did nothing, as we would say in industrial relations, engage in the commission of an act or acts that went to the root of our employment, then you have no recourse than to re-employ me. What is this nonsense in the space that you're telling people your contract come to an end? And this,
I wanted to bring
this authority is doing that. It's pure nonsense.
I wanted to bring that question up as well. Can you do that? Can you say, hey, you was running on a 3-year contract or a 1-year contract, and the time comes up to an end, right? You come to the end of the contract period, right? Even though it was a good worker, the company might have some intentions of restructuring, or they might be laying off, or whatever the case may be. And they'll just let the contract run up to its end and then tell the employee, all right, thanks for your service, you can go home now. Is that something that an employer could do under law? Is that lawful?
Well, it's unlawful, really. And let me say this. I want to use the International Labour Organization judgment as a guide, right? Just as a guide. Even the president of the court in her recent book used those judgments as a guide. And then we'll come to some national cases. But in this particular case, in 2014, Judges Bagalo, Moore, and Rawlins, in this extract, it says, an international organization, whichever organization, that's what it means, has a duty to inform a staff member in advance about the non-renewal of her or his fixed-term contract, to enable the staff member to exercise her or his rights and take whatever steps she or he sees fit. On this basis, the tribunal requires an organization to give reasonable notice, even where a provision in the contract of the staff member or in the applicable rules states that notice need not be given. So the court is saying, even though there's something in the rules that say, I don't have to notify you, the court is saying, has overruled that position and said that you must notify me.
You must notify.
But that's one aspect of it. But the ILO addressed another issue where an employee was in the organization for about 7 years, as we see in the case of the assembly. All right? And it is basically saying that the long succession, quote, in this extract, the long succession of short-term contracts gave rise, listen carefully, so I've been here working with you all these years, and the court is saying that gives rise to a legal relationship between the complainant and the employer.
So you said that could be like an implied contract in its sense.
Yes, it's impliedly, yes, that's what it's saying, that you must, if I have a significant amount of years with you, even 3 years on a legitimate expectation, even 1 year on a legitimate expectation, but it's saying more so in a long-term relationship, it is saying here, in considering that the complainant belongs to the category of short-term employees to whom the staff regulations and staff rules don't apply, and who do not enjoy legal protection comparable to that enjoyed by the other staff members, the defendant, which is the employer, failed to recognize the real nature of its legal relationship with the employee. In doing so, it committed an error of law and misused the rules governing short-term contracts. So they're saying short-term contract employees have the same standard and protection than permanent employees.
Right. Let me carry to Clyde. Clyde, I wanted to ask you the same question, about the fixed term, employers letting the contracts of the employees just run out without any prior notice, no issues, and then they end the contract, even though the position is still available, just telling them, all right, thanks for your service, and send them home. Is that right? Is that something you could do?
Well, it is not right. The point is that if the contract comes to an end, but the function remains within the organization, then that person who has been performing that function should continue to perform the function. Now, within the contract terms, there may be, as expressed in some cases, I think I dealt with a case with UTT 2 years ago, in which the court says that the contract may be renewed based on performance, and the organization contrived to make it appear that the worker's performance was not up to par, but there was no proper performance appraisal that said so. So in the THA, for example, one worker was denied his contract gratuity. And the claim was from the chief administrator that he did not perform well. When we examined the case, the person had not had a performance appraisal done at all during the 3 years of that contract. So there was no basis for the employer to say that I could deny you even a benefit due under the contract or a renewal of the contract since the function is continuing based on performance when I never actually properly measured your performance during the contract period. Now, those are ways in which the employers try to get around this thing. Now, if I work for a fixed term contract and I work 1 day beyond that, in law, I have begun a new contract on the same terms as the previous one. And some employers really played smart with foolishness. They let an employee remain beyond a fixed term contract period, and then tell him, "Sorry, your contract ended last week." No, you can't do that because the person is on a new contract on the same terms once they continue to work. So it's a whole range of things that employers are doing. And the industrial court, like I say, examines every case on its own merit and examines in detail, is this a ruse to treat permanent employment as contract employment? And in the public service, the biggest issue with that is, like I said, permanent pensionable employment is public service employment, is public officer employment. When you remove that issue of the pensionable status by having a fixed term contract, in the public service, there are several rules in which you could have somebody on contract at all. Either you have, as you discussed earlier, Mr. Moderator, a job to be done over a fixed period of time with a deadline. So there's a fixed period of this job. Or that there's some expertise that we require that is not available among the public officers. So we can hire somebody on contract. I went to work in the Ministry of Legal Affairs in 2010, and I met telephone operators on contract, drivers on contract. What is their special skill, or what is the short-term necessity of that job to have them on contract? There's none. But the politicians, like I said, since the NAR days in the 1980s, have been trying to have the right to hire and fire and to bypass the service commissions. So what they've been doing is hiring more and more people on contract. Let me just give you this example. During 2013, I discovered somebody in that same Ministry of Legal Affairs who was a temporary employee after 20 years. And when I wrote about people being on contract as drivers and telephone operators, I did a letter to the newspapers. The then Minister of Public Administration called me one morning as I was getting ready to go to work in my house. And she said, "What is this you're writing?" I said, "Well, I'm writing the truth." And she said, "Well, you know what's happening? In my ministry, 75% of the people in here are on contract. They're not public officers." That is the Ministry of Public Administration, which is supposed to be the exemplary ministry in terms of human resource management in the public service. So when you go to the THA, for example, when the THA Act was first passed, there was the issue of what are these people in the THA? What are they? Where are they? Are they public officers under a commission? Are they employees in a statutory body? Where are they? And there were several matters that came up over that early period. Now you have a lot of them being on contract. Take the people in the RHA, for example, of which the Tobago RHA is one of them. When the Regional Health Authorities Act was passed, what the effect of that was that you took 1/3 of the public service, doctors, nurses, attendants, every tooth moon who were in the public service, pull them out of the public service, put them under these statutory bodies on contract. And you have to understand that if you take a doctor who is on a permanent pensionable employee in the public service and make him a contract employee for a 3-year contract, or a nurse, they cannot get a car loan from a bank because no bank is going to lend you a loan for 3 years. You can't get a mortgage and so on. Then the issues of pay and negotiating pay and overtime and so on. And in 1997, I negotiated overtime pay for doctors. These things become important because you're no longer in permanent pensionable employment in the public service. So contract employment, as is happening with the TTRA, for example, is going to take another chunk of the public service out from the public service, as well as happened with TT Post, because the postal function within the public service was removed and put under TT Post. And you know that those people in TT Post, in the RHAs, in fact, among the RHAs, the ex-public officers do not have a recognized union up to today. Up to today. So they have no union to collectively bargain on their behalf.
Question to ask, and then we will move on to another. We'll take a break and then we'll move on to another topic, right? I want to draw the attention to retrenchment and benefits from retrenchment, because we touched on it earlier. We had CPEP. I remember that CPEP is under community development, right? And early in the administration, current administration, they would have boasted that, hey, when we did our audit of CPEP in the Tobago branch, we realized that CPEP was very administrative heavy and management heavy. All right. So what we did is that we restructured so that we could have got rid of the positions that were needed administration wise and management wise, and we were able to raise the salaries of those that remain and the persons on the ground who actually doing the work, the workers who actually cutting the grass and whatever. So those would be the daily paid workers on the ground, right? What the fallout of that, the fallout of that would have been, there were persons who were working within that office, CPEP office, on some 10, 11 years, who were just on contract again, who were just let go and told in some instances you could reapply for this and that. And they will let go with just a thank you. And in some instances, you have a lot of people who have commitments, they have children, they have whatever. Is that something right for our organization to do?
Right. So let me just quickly go back, stay half a minute on it.
Mm-hmm.
When the assembly came into being in 1996, so to speak, following up from Act 32 of 1980, and a number of divisions were created under the Act number 40. And of course, you have to populate those divisions based on the new functions of the Tobago House of Assembly, mm-hmm. or Act and so on. And a committee under deceased Dr. Morgan Jobe was established. She was the Minister for Tobago Development, Tobago Affairs. And he took about 3 years. In the meantime, the divisions had to function, the public services had to function, had to go on. Mm-hmm. And there was no other recourse than to put people on contract. So that's where it originated. Mm-hmm. I myself was very much heavily involved in that as the Labor Secretary. So we had no other recourse. Mm-hmm. But continuing on, I would have expected the PSA at the time where Clyde had gone out of office, because certainly he would have addressed it. I know, because we worked together. Mm-hmm. But you found that the Public Services Association would have dropped the ball and not argued vociferously for those contract positions to be converted into full-scale permanent public service employment. Now, the danger of it, as Clyde went to tongue on it, is that you do not have a pensionable position any longer. And therefore, going through the years, down the years, you virtually get nothing after gratuity. So that kind of decision making is not in favor of the working class. You can't take 41 persons out of the working class, put them in government. You can't take 15 persons out of the working class. Some of them who never held a flag or marched for any
Workers' rights.
any right or any purpose at all, any good reason. But we'll tell you today, we don't want you. So let us come to the immediate question of the restructuring. And the court will look below that veneer, as they like to use those kinds of language, to look to see what was the real purpose of the restructuring. And my only advice is that we should stop that kind of purported restructuring. It is wrong. It is egregious. It is plain wicked. It is unconscionable. After people would have voted for you, you discard them. You discard them for insufficient reasons, for reasons that are not overridden by any public interest. So I can only advise, if they want to take the advice, speak, because they have the power to do so. They have the authority to do so. They have the political, they should have the political will to do so. Let's talk with the DPA, let's talk with the CPU. Let's talk with the Minister of Public Administration. Let's talk with the Minister of Finance in this sense. And have all these positions go through the public service here in Tobago, reorganize all of the divisions and put all of those people on permanent public service positions. There are a lot of positions that are unfilled. And for me, for the life of me, because I remember in my time, there were certain secretaries that wanted to give people contracts for 3 months. I told the chief secretary, no, that's wrong. How can you you can't go to the credit union on a 1 year contract, a 2 year contract. And I set about to correct it. And thankfully, that chief secretary at that time followed my advice. And I think coming down to the years, even in the last administration, they eventually, because I would have this particular document here that we're quoting from to the last chief secretary. Look, listen, and they agreed that contracts at a minimum should be 3 years.
Okay.
But I advocated somewhere in this document for a 5 year, because that 5 years is the minimum threshold on which a bank will accept an application for a loan.
For a long-term loan.
So that, and you see when people say 5 years, but you always retain the right to fire. You always retain the right to dismiss. But you are helping your public officers. You are setting the tone even for the private sector. But more so, the people who pay your salaries, who do the pay sheets for, who do your work, make you look good. You owe it to them to give them a 5 year contract in the minimum. Now, I don't like the contract thing. There should be public officers, as Clyde will agree. But the next best situation, as they would say in negotiations, BATNA, best alternative to a negotiated agreement, is to give them a 5 year term. It is not a bad thing. It is not uncontrollable. You always have the right to control, particularly if you do your human resource management properly. But you want to manage without human resource management. You want to discard it, and do what you think you should do. They want control. But the best control is if you, as we know in management, you set smart objectives, you manage by objectives, and you use your tools of appraisals like your 360 or your multi-rater and so forth. If you use, let's say you use the multi-rater tool, for example, is where different levels of the organization will grade the particular team or the particular officer. And you'll know if they function, because your targets or objectives or your goals would not be met or might be met. So that when different levels of the organization in a vertical line grade you or rate you, as the case may be, There's nothing wrong with that. That's what we've studied. That's what makes organizations successful. So employing, go head on, take full charge of those tools of human resource management and let it work rather than say, I will fire you. This man ain't doing what I say, so I'll... No. The safer way for the politician, and tell me if you agree with me, Mr. Moderator, if I let the human resource management concepts and principles work, the politician ain't have nothing to blame because you would have purged yourself out of the organization by not performing.
Very much so.
And if you truly have to restructure, let's have an executive council minute. Let's have a board minute. Let us have the directives in the proper way, and so that everybody can see, the public can see it's done over above board.
Over a period of time, yeah.
But
it's a process
but
that was taken.
And that's what the court looks at. If you haven't done those things, then you're not going to win at the court.
Make it liable, make it
But the important thing is that you can redeploy people in a safe, in a proper and effective way, rather than put people on the breadline. And I'm not for that at all, because there are other options and there are better ways to dismiss or non-renew, as the case may be. I'm saying, have we tried those?
Right.
And if the answer is no, then we have a problem.
Right. I have to take a break. Let me take a short break, and when we come back, we'll just touch on the other two topics that we have. Right? So stay tuned. We'll be right back.
Light up the Christmas with the best fiber. Surfboard channel switch to Amplia. Thousands in prizes, plenty smart TVs. 1 year free service and free groceries. We surfing with Amplia. We winning with Amplia. We binging with Amplia. We winning with Amplia. Sign up now for 50% off plus a chance to win over $100,000 in prizes. Call 800-4663.
Hey, hello guys, welcome. Come have a seat. Oh, this is so stylish and I love the fabric. Darlings, you must tell us where you got your new furnishings.
We got them locally at Standard. They've got new chic European furniture, crafted from high quality material.
Oh, Standard?
No, it's Standard, their brand new Hive collection.
Experience luxurious European furniture at a price you will love. The Hive Collection. Now exclusively available at Standard.
Tobago Glass Supplies has been a leading name for over 37 years in the glass and aluminum market in Tobago. We provide an extensive range of high-quality, innovative aluminum and glass products for commercial and residential use. Competitive prices with superior and professional services by committed employees who are guided by rigid quality standards. Tobago Glass Supplies specializes in the manufacture and installation of glass and aluminum products that are essential to today's homeowners and the business environment. We are engaged in marketing, sales, and installation of a variety of products. These ranges from windows and doors to necessities such as mirrors for homes and vehicles, designed and manufactured in-house or imported.
All right, and we're back. And we, in case you're just joining us, we are talking about labor. And we are touching on several topics under the topic of labor. And we just before we move on to the next topic, we want to touch on just one more small subtopic to fixed term contracts, all right? Because it is important that we get this one through because it's a very prominent issue that has been occurring in Tobago space of recent, all right? So we want to, if the director could pull up case D, all right? All right. And I wanted to ask Mr. Clive while he's there, when it is that the employer allows or they fail to renew a worker's contract without any kind of notice from beforehand, is that something that, again, an employer could necessarily do? All right? Mr. Clive, you there?
Yes. The thing is, you have to, again, the court would examine the particulars of that particular case, right? Now, the question is that in the Industrial Relations Act, a trade dispute in the definition in Section 2 of the Act of a trade dispute includes not only issues between an employer and employee in terms of negotiation and terms and so on, but the question of employing somebody or not employing them, and the question of terminating or non-renewal of a contract. So if you do not renew my contract and I go to the industrial court, the court will have to examine, have you not renewed my contract for a proper reason and with a proper process? So if you are not going to renew my contract and the contract says that it may be renewed on the basis of performance appraisal and good performance and so on, and there is good performance, and then you turn around and not renew it, then you have effectively terminated me, and you have not terminated me on a ground for which you have brought an issue to me of bad performance. So if you have not done that, it means that you have not, in that sense, given me notice, not the normal notice period in the contract in that sense. You have not brought it to my attention that you intend not to renew my contract. And good industrial relations practice in Trinidad and Tobago, as that case points out, is that the employer needs, before you terminate somebody, to bring it to their attention of what your intention is and give them an opportunity to raise things in their defense.
Let me bring in Max. Max, let me touch on it real quick before we move on, because I really want to touch on the rest of the topics for today.
Well, the case is clear. And Clyde can have said it, but the case is clear. It says in the second paragraph of the case, further, it is well settled. This was a test case. And it reiterated that particular case or dispute in 2001. And there are numerous cases that deal with fixed term contracts. The general direction of the court is to examine why you are not renewing someone's contract. Apart from the social reasons which I believe employers must consider, because you're putting someone on the breadline. And why would you want to do that without a good reason? If you did not address performance, then the courts, even at the International Labour Organization level, whose judges, by the way, are drawn from the Privy Council. So you could actually say it's a Privy Council ruling, if you will. All right? However, it is saying here, if they could put back on the screen, so I could read it for the public, so the workers can see their rights. It says in the second paragraph, further, it is well settled that a failure to renew a fixed term contract upon its expiry, these are Max James' words, can be a dismissal which is harsh and oppressive or not in accordance with the principles of good industrial relations practice. And quickly, when a public official can tell workers, although don't worry, all they're losing all their job. From the time he says so, the court says that assurance is given to the workers. That was in the appeal court case, a Mediterranean a Supreme Court appeal in Mediterranean woolen mills and so forth. It says, so if you come and you give me an assurance, then I have a legitimate right to expect to be renewed. And that's what the senior public official did. So that, and I dare say he can be called to court to give evidence. That is what's most likely going to happen. And even though he might end up being a hostile witness, but we really want to have the officials here in Tobago follow the law. Don't abuse your authority. Don't listen to those smart lawyers who will tell you otherwise, who want to make money off of you, right? At the expense of people who voted for you, and some people have a right to a living, a decent living. Where are they going to find jobs? They take about between three. The stats show you that when someone is fired, it takes about 1 to 3 months before you can gain some kind of employment. But not in the Tobago space, because we already saturated.
The job market is already hard.
So you actually killing me. That's what it is. You're sending you're sending those ladies who might have left their boyfriends because the men are not coming up and functioning properly as good husbands and partners and so forth. Where you sending them back? To the arms of those guys? And where those guys are going, if they can't support their families, what are you doing to them? It is a significant socio-political issue that we must walk on eggshells. We must be very careful, as the courts will tell you, it is dismissal should be your last object, your last port of call.
Talking about punishment now, right? Talking about punishment. Plenty times we see in organizations, this is not unique to the THA, happens in private sector too, that we have some kind of there's personal feelings or personal ill will between two parties, whether it be a boss and a subordinate. And you see where the employee, you're watching them and you're putting them under a microscope, right? And the minute that employee slips up, the harshest of punishments are being levied on that employee, right? Is that something that, and I'll put this to Clyde first, is that something that an employer could do? Can you just, the first little infraction, the harshest of punishment, you're going to suspensions, we're going to docking of pay and all these different things. Is that something that an employer can do?
Is it proper? In our situation, the industrial court for many years has laid down what is good industrial relations practice in respect of discipline. And there is the notion of progressive discipline. You don't take somebody on a first offense and treat them as though it is a capital offense and they need to be terminated. The objective of discipline within an organization is to try and assist the employees to correct any faults they may have and to get them to better perform within the structure of the organization. So, first of all, question of progressive discipline and therefore the applying of penalties to suit the particular transgression, if it is proven, has to be observed. So, for example, if I carried out a robbery and I didn't kill anybody, you can't come and impose a death penalty on me. And in employment relations, dismissal is a death penalty. The question here is that you have to, the penalty has to meet the particular transgression. And not only that, before you arrive at a penalty, you have to have the person's right to be heard and natural justice applied so that you arrive at a proper decision as to whether there's innocence or guilt in relation to a charge of misconduct. You can't just go turning around people and charging them and firing them just like that. They have a right to be heard. They have a right to have natural justice applied to them. And the industrial court is full of judgments on those matters. Now, when you mentioned earlier just now about restructuring and what happened, and I can tell you, in terms of BWIA to CAL, you remember that happening in 2006 thereabouts, right? That a BB plane flew out of Trinidad one night and flew back in the next day as a CAL plane. Now, what for the workers, what did that mean? For most of the workers, they remain without a union up to this day. The only employees of BWI who are in a union at the present time are the pilots, because they are a very tight, close group, and they were able to have TALPA reapply for recognition as the Pilots Association in CAL. For the rest of the workers at BWI, from the air hostesses down to all the technicians, etc., there is no union representation, and that is one of the outcomes of restructuring. And basically, that is what we have been told is restructured in the public sector. That you end up with contract employment, you end up with no union, and you end up at the mercy of employers beyond that point in time. When these kinds of things about basically harassing people and then turning around and terminating them or imposing the harshest penalty for the smallest infraction without proper natural justice and giving them the right to be heard and so on.
I remember, right? Before you go, I remember there was a time, and it just come up in my mind. In my younger days, you could say about 5 to 7 years ago, right? I know I'm young still, but in my younger days, right? There was an issue at work where admittedly I would have made an error, all right? And it would have caused an issue to arise where an employee was accosted in public by a customer, right? Because I didn't address it. It slipped me. And when the managing director saw that, managing director came, we're holding you liable because I was not the person who did the service and caused the customer to be upset, but I was supposed to be the person who recovered the service. We're holding you liable for this and that. And there were penalties such as docking of pay and suspension and all these different kind of things. And I'm like, a small error such as that could cause somebody, and in that space of time, I'm thinking, this can't be right. Obviously, obviously, it cannot be that an employee, because you deal with humans, you're not dealing with robots, so mistakes happen. Invariably, they happen. And so it's not if a mistake happens, when one happens. So you're saying to the employee, hey, when it is you make a mistake, we're not giving you the chance. Yes, we're just going to shaft you. We're just going to shaft you straight and, plain talk bad manners.
So let me advise everybody, particularly heads of departments in the private sector in particular, or quasi-government companies. Mm-hmm. We have a few in Tobago. And if you don't have, in fact, when I was a labor secretary, I ensured that a document that I produced called the minimum terms and conditions for workers on contract in the assembly. Mm-hmm. It was amended by somebody who they brought from Trinidad that didn't know the language changed up and so forth. But I insisted that there should be a code of conduct inside of it, mm-hmm, and a list of penalties so that it gave the workers a chance and it gave the company or the institution organization. Mm-hmm. It gave them organization. So that the idea is that we must know, because the court is going to ask, because otherwise you're going to be arbitrary or perhaps even unilateral. But we talk about bilateral relations. From the time you have workers in an undertaking, you talk about bilateral relations. I want to urge everybody, workers in the assembly, in TATCO, in what's your company? 211 and all the rest of them, be unionized. All those pretty girls who believe that they should spend money on makeup are just making a joke, ladies. That be unionized. Because you do not know when you will make a mistake. And there are people outside there setting like Mapipi if they don't like you or you're not on the right political side to catch you. And if you are not unionized at least 8 weeks before your matter comes up, then you're in problems. And also the things that the union officers and consuls and myself have to do to help the situation. So I am really employing workers. The beers that you're drinking, the outings that you make, the nice pong in your car, all the nice phones you go in and pay at Digicel and TSTT and all of that. That is money that you could give for your own employment protection. Be unionized. The law says that you should not be victimized for freedom or for associating with a trade union or joining a trade union. My lecturer used to tell me it is always better to have a half-dead trade unionist than none at all, because he will save you. So turn around, workers. Turn around and understand that it must be right. But in the specific question, the workers should insist that there should be a code of conduct as part of the terms and conditions. Even a contract is a term and condition of employment. But we should add to that, where there is no existing code of conduct, the workers must come together and tell that organization, we are insisting that a code of conduct should be drafted up and a list of penalties for breach thereof. So that you wouldn't have to, you'll cut out arbitrariness, you'll cut out vindictiveness, because there'll be a process right up to a tribunal and the next step to the industrial court, as the case may be, we're going to register a dispute and so forth. So that code of conduct should have all those steps, a grievance procedure. So you have a grievance procedure, you have a code of conduct, and you have the penalties, and you have the process right up to the Ministry of Labor. Barring that, they go to the court, right? So I'm hoping that after tonight's program, we will see a change in Tobago. We will see where workers should come to the workplace knowing that they should not or would not, hopefully, be victimized. And it's not a question of us versus TPP or us versus PNM. And PNM did it, so we should. That is illogical. You hear the argument that PNM did it. So what? Do you want to be like the PNM? Oh, they closed on the Ministry of Tobago Development. So do you want to do that too? Do we govern by recrimination? We promise not to govern by recrimination. We're supposed to set new standards of governance in Tobago. Let the assembly and employers, let the assembly set the tone for good industrial relations practices in Tobago. And I'm urging private employers to set the right examples and right tone, and let us follow the law. Do not take advantage of your workers. If they have to be disciplined, fine. If they have to be terminated at the end of a process, fine. We have no quarrel with that. But there are principles and there are laws and there are case precedents that you should avail yourself to or of and follow them. That way we'll have more productivity. That way you'll have workers who will support you because they view you as representing their interests and supporting their rights.
Yeah. Right. And just wrapping up now. I always saw at the end of the day where you have, and you alluded to it as well, when you have workers who are empowered by, or they know their rights and they're empowered by their rights. Again, you could breathe easy, and you could do your work, right? Not when the time comes up and restructuring coming around, or your time come up for renewal of your contract, you're uneasy, you want to know if it is, you know, the employer will give you something or whatever. That should be in a case where it's a foregone formality, in the case where you know that you're safe because you're doing your job. If you ain't doing your job, and by no means am I advocating for keeping people in positions who are not performing.
I'm not doing so either.
Exactly. And nobody here on this panel is doing that as we speak, right? But once the employee is doing his or her job and performing admirably in that job, that employee should not be feeling uneasy when the time comes for a renewal of contract.
But the court is saying that is advising employers in all of its judgments that regarding dismissal and non-renewal of contracts and so forth. Do you have a system in place in which to appraise the function of the employees? That's the first step. Why are employers across the board, public and private, not developing and ensuring and insisting and putting in place and managing it a system of performance management?
Right.
Is the first thing. You can't get the best out of workers if you don't have standards. You don't have performance standards. There are numerous of them. What standards are we setting? What goals and objectives are we setting? How are the workers meeting those things? That's the first thing.
Right.
And before you even think about dismissing. So if based on the standards that are set, and where you can measure those things, smart objectives as we call them, or management by objectives as we call them, and you can measure those objectives. They are timely. You understand what I'm saying? They are measurable. They're specific. They're actionable. They're realistic, and they're timely. Smart objectives. Or you manage by objectives. You tell workers this is where we're going. And then you use the performance tools. My favorite ones are 360 and Multi-Rater. I'm urging employers, particularly in the public service, please let us embark on a system of sound performance management principles and practices. Let us build a first-class public service. That's what I'm advocating for. The first measure is not to send home workers. Give them a chance. But the court will ask, what were your goals and objectives? They will ask, what did you do? Where are your performance standards? What is the process? And so you think that firing someone because you want control. We should not be controlling in that powerful, wicked way. And an authority given to you is not to punish workers because you don't like them, or because some other party did it, or because some other party did it, or some other person doing it. Let us determine the right paths in which we should prosecute our goals and objectives.
Right.
And I think that we are failing there, and I think that we should turn around and do the right thing, and let us have industrial peace and productivity at the end of it all in Tobago.
All right. So, just as we'll be running out of time, so I have to wrap it up now. As you touch on the political, I just want to say something, just quick, 10 seconds. We already have jobs are hard to come by in Tobago, no, one. And two, the talent pool is already small. We're losing persons to Trinidad and internationally, right? Persons who come and study and certain expectations, they go to work for whatever company or whatever public sector. They reach up the problems that they have in there with victimization or whatever political party put you in there. And so the next political party come, we can't afford to do that, right? The pool in Tobago is already small. We need to empower workers. We need to keep the best workers we have here so that we can realize our goal, right, of becoming the best small island on the planet. All right. But with that being said, I want to thank the panelists for coming on tonight. A wealth of knowledge between the two of them in industrial life. You probably, well, more so, because one of them probably have more experience than I have age, right? So we know that the information that we got tonight was well informed, all right? And so what I want to do, I want to thank Tobagonians for listening to tonight's discussion, and we will continue tonight's talking about these pivotal topics that affect Tobagonians. All right. So, but until next week, Tobagonians, mind your business, know your rights. All right. And I'll see you next week. Have a good night, everybody.